for taking the time to do this. Thank you for taking the time to do this class with the agents, with the Canvas agents. Today, we're going to talk about the assist contract. And please, if you have any questions, let's do the questions at the end. Inalvis is going to be, kind enough to go through all the ins and outs of the assist contract and the Florida bar contract. So, Inalvis, thank you so much. We welcome you.
Thank you. It's my pleasure to be here with all of you. And again, a pleasure to be here with Canvas Real Estate. So the purpose of the class today, I think, is to give an overview of the contract. And I hope that I'm able to go ahead and help you guys with that. As always, we're going to take the questions, but we're going to do it at the end of the presentation. So what I ask you to do is please write down your question, because as we go, then you might forget about your question, and I don't want anybody to leave the training with any doubts. Okay.
Excellent. Excellent.
Okay, so how do you want to do this, Leo? You're going to be asking me questions about the contract, or you want me to go down the contract?
No, basically, what all the agents probably know by now is that we don't change the contract. The only thing is we fill in the blanks, because the contract were drafted by attorneys. So basically, our job as agents is just to fill in the blanks and to select the different options that we have in the contract. The first thing that we have on the contract is going to be the buyers and sellers. And one question that I had yesterday, but actually one of the agents called me and asked me if they should write down on the buyers the name of the buyers of the way that it shows on property records, which was a trust, the name of the trust. So that's the first question. There you go. When you're writing down a contract on the buyers or sellers, you should use what is already on public records or the actual name of the buyers or sellers.
Yeah, let's talk a little bit about that, because there's plenty of confusion about it, especially with in your case, especially with the trust. Okay, so the first thing that we do whenever we're preparing a contract, we need to know and we need to find out who the seller is. Okay, and for that we go to the public records, or sometimes you use your program IMAP, and IMAP tells you exactly what the public records reflects. Okay, then we have to find out, if we have a typical individual, then the name of the individual is going to be there. But remember that no matter, let's say that you have more than one, 3, 4, 5, it doesn't matter how many sellers or how many people they're there in the poly records, you need to include all of them. Because if you include only one of them, okay, then you don't have all the signatures for every single seller, and then every single seller has an interest in the property. Okay, so you're starting right there the transaction incorrectly, because now you have a contract that could easily be terminated, or it's a void contract. Okay, so always include all the names. When you look at the poly records and you find, and I'm going to get to the trust last, but when you go to the poly records and you find a company, okay, how are you going to find those? ABC LLC, that's a limited liability company. ABC Corporation, ABC Inc., those are corporations. ABC LLP, that's a limited liability partnership. Okay, it doesn't really matter the type of company. The first thing that you do is you're going to include, as the seller, the name of the company. Okay, remember that the property belongs to the company, okay, not an individual. So you're going to list, let's say it's ABC LLC, that's going to be your seller, ABC LLC. But keep in mind the following, because this is something that happens a lot, okay? You include the company as the name of the seller, but you have to go find out who has authority to sign that contract. The contract is not going to be signed by ABC LLC. The company itself doesn't have authority to sign anything. You have to find an official of the company to go and sign the contract. So what do? My recommendation is you start with zombies.org. Okay, zombies.org, you do an entity search, and then you go ABC LLC in my scenario. When you do the search and you find the company, you might probably find out that Ina Zubiaur is the manager of the company, right? So Ina Zubiaur is the person that's going to sign. Sometimes, and the reason why I'm saying this is because sometimes when we use that loop, right, or we use DocuSign, any type of electronic signature, when we put the name of the seller to collect signatures, we have the habit, or we, you know, have done this in the past and we have never been affected by it, of saying A, B, C, or C. And then when they generate, the signature generates, guess what? You're going to find a signature that says A, B, C, or C. Okay, that's incorrect. You need the manager, the president of that company. In this case, it will be Ina Zubiaur. So when you send the contract, you put my name, and then the signature is going to be my signature. How? As the manager of the company. Okay, so seller the company, signature of the individual. Keep that in mind. Lastly, trust. This one is complicated, okay, and it's confusing to many agents and to many people in general, not agents, you know, everybody. When you go to the poly records and you find the name of a trust, the seller is the trust, okay? So you're gonna find something like Ina Zubiaur, TRX, that's trustee, okay, of the, or it's not gonna say of the because they're trying to be sure, it's gonna say Ina Zubiaur revocable trust, dated, you might not even see the date because it's too long, okay? But dated 1/1/2022, for example, right? You know now that you have a trust. Who's the seller? The trust, Ina Zubiaur revocable trust. Okay, you have to put it exactly as you see it. My recommendation with the trust is because the names are very long, the counties tend to cut the name. So you're not gonna see the full name of the trust. So what I recommend is that you go and you put the warranty deed, the last warranty deed that you have it, you have access in the poly records. If you go to the sales section and you click on the blue link, it's gonna take you to the warranty deed, get the full name of the trust. That's what you're gonna include as a seller, okay? The trust is your seller. Who signs? The trustee. Who's the trustee? The records are telling you that the trustee is Ina Zubiaur. Okay, so Ina Zubiaur is going to sign the contract as the trustee of the trust. If you have any doubts about who the trustee is, this is the time for you to go to the listing agent and tell the listing agent, hey, I need to confirm that the person that's going to sign the contract is the correct trustee. Is Ina Zubiaur the trustee of the trust still? Because trustees could change, okay? If they tell you yes, then you know who has to sign. If they tell you no, then the next question is, can you send me the page of the trust that has the name of the trustee, okay? And the trustee is the person that has authority to sign the contract. That's when you're dealing with sellers. When you're dealing with buyers, okay, keep in mind that all buyers must be included in the contract, okay? And when I recommend with the buyers is that in addition of including your buyers, you also tell me if they're married, if they're single, okay? What is their marital status? If you have a married couple, you have to include both names, and you could add husband and wife, okay? It's not a requirement, but I recommend it. Why? Because if you do it, you're already telling the lender, this is a married couple, and you're telling me, you know, and when I say me, I talk about title logic, you're telling the closing agent, this is a married couple. I already know that my deed has to reflect that they're married, okay? So keep that in mind. And when we're talking about buyers and sellers, especially the buyers, the spelling of the names is very important, okay? Sometimes we do not include the correct spelling, and then what happens is that because we work based on the contract, every document that we produce or that is produced by the parties in the transaction after the fact that the contract is signed is produced with the incorrect name, okay? So I recommend that you get driver's license of your clients and confirm the spelling of the names from the get-go.
When you have an international buyer or seller, you're going to use the passport as a document, correct?
Absolutely. You use the passport, and it doesn't matter, you know, that well, we all do in our countries that we have a name, a middle name, and 2 last names. You know, usually that's how it goes. International buyers, the full name, okay, as it is in the passport. Don't cut a last name, okay, because they haven't changed their name legally in the United States.
I got it. Gotcha. Excellent. 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 The answer. Now, if we move down the contract and we go to property description, sometimes there's mistakes on the MLS. So we don't need to go by what is on the MLS, because sometimes the property description, the tax ID, even the address has some issues. So what do you suggest we use in order to fill that line, those lines correctly?
Yeah, my recommendation is you work with the MLS, okay, because that's where how you find the information, but take it as you're working with it to find the property, okay, or to find the transaction. What my recommendation is always go to the public records, okay? What is the public records? Where do I find the public records easily? You go to Google and you put the county, let's say Miami-Dade, property search, Broward County, property search, Palm Beach, property search, any county with the term property search, that's gonna take you directly to the page of the county, okay, that reflects the property information. And that's where you will get the correct address, the correct folio, and the legal description from, okay? What happens is that with the MLS, because sometimes agents do things in a rush or they don't pay attention, they could easily change a folio number. They could easily change an address. And remember that when you start a contract with the incorrect address, you might be selling the neighbor's property, okay? Not the property that you want. And the problem with that is that if you have a contract with the incorrect address, that contract is invalid. It doesn't work, you know, because now you have other owners that are not the real owners of that property signing the contract. You don't want to be in that position, okay?
So what happened in that case? The contract automatically goes null and void? Yeah,
the contract is null and void because now you have a contract that the persons assigned do not have authority to sign for that company, okay? I'm sorry, for that property. So it's null and void. It's a great opportunity for a seller to walk out of a transaction, you know, because think of the scenario that the seller accepted the contract and then 2 days after they came and now they have another offer, a higher offer. If the contract is null and void, you didn't have anything, there's no obligation, okay? So it creates the possibility for the seller to walk out. Remember that the seller does not have that ability as often as they would like during the transaction, okay? So property address, highly important. Folio number, highly important. Legal description, super important. Remember that everything that we do with properties and as a title agent, everything we do is the legal description is more important than anything else, okay? For your purposes, the address very important because you might be selling the property of the neighbor, which is not correct, and the contract will be null and void.
On the cases, for example, when we have a sale of the piece of land and that the legal description is this long, do we have to put everything that is on the legal description?
Yeah.
And if we don't have a space, can we do it on a separate form?
Yeah, I actually recommend that because look at what happens. Vacant land, sometimes you cannot even find a property address for them. Which is complicated. And so what I usually do and what I usually recommend, you only have 3 lines for the legal description, okay? And vacant land, when you don't have an address, the legal description is key. So what do? You could do something like C Exhibit A or C Addendum A, okay? And then what I recommend is that you do not go and type the legal description, okay? Why? Because if you have a legal description this big, then you might miss something, right? So what I recommend is that you find the previous deed, okay, which you're gonna find that in the public records, again, at the bottom where it says sale history, there's usually a link that you click on it and it takes you to the warranty deed, okay? What I recommend is that you get the warranty deed. Usually you're gonna see that the warranty deeds have an exhibit as well, because they're so long that we don't type. We get the same exhibit from the previous deed. And you could even get that page and add it to the contract, okay? Or get that page, cut the legal description, paste it in your addendum, okay? And use that one. You're better off doing that than typing the whole legal description because you might lose something, okay?
Excellent, excellent. So going down the list, we're gonna talk about personal property included with the sale. I remember back in the day, like again, when it was only 5 pages, you had to write down exactly what stays with the property. But now it comes with, you know, with the dishwasher, refrigerator, range. Now, the question that I have for you there is what happens if at the time of showing and when you submit the offer, there is some appliances that when you do the closing, they change the appliance.
Yeah, remember that personal property, and I usually do it, I usually explain it this way. What you see, you get, okay? So when there's a showing, if you get to the property and the kitchen is included with, because it is included within the actual language that you don't have to add it. I'm gonna tell you the 3 things that you have to add, but everything else is included. And when you get there, you see that they have a stove that is KitchenAid. They have to sell the property, they have to give it to you, to the buyer, with a KitchenAid stove, and you cannot even buy or replace. It has to be the one that you saw, okay? So that's something that you have to keep in mind. Whatever you see, you get, remember that. And if you're representing a seller, remember that I always recommend what the seller does not want included, you remove before the showing, okay? And if you didn't have time, then you have to exclude it in the contract, okay? If you do not exclude, the seller is gonna have to leave it. Okay, that's the rule. Okay, so when you look at the description of personal property or the things that are included, and remember that the description changed and they added new things in 2021 with the last modification, there's 3 things that they did not add. Okay, and we've been working with the same 3 things for the past few years anyways. Okay, washer, dryer, and microwave. If those are included and you see them, you have to include them. Okay, you have to actually type washer, dryer, and microwave in the line.
So
okay,
that we go on in line 21st, is going to go the washer and dryer and microwave in those stays.
Exactly.
Now, do you have to be specific about existing appliance at the time of showing? Because it happens to me, The question, it comes because it happens to me that I get to a walkthrough, and then the appliances that were there, they were not the one that were at the time of showing. So we have an issue with that because it says on the contract, and the listing agent was playing smart with me, and it says no, that on the contract say appliances. It doesn't say KitchenAid or Sub-Zero or it. So what's the way that we have? What's the tool that we have in order to protect our clients if we're working with a buyer for that not to happen?
Okay, you could definitely describe it, you know, like a specific with the brand of the appliance. Okay, you could do that, but because it's actually things that they're already in the contract, you know, you don't have much space. Okay, so you could do it in the form of an addendum, or you could do the following, which is what I always recommend my tenants and I recommend my buyers. Okay, take pictures, take a video. You're seeing the property nowadays that everything is technology based, right? You could easily go and whenever you're with your client, take a video of what the client is seeing. And that's exactly what they need to provide. There's evidence, okay? So that's a good way to make sure that they're giving you what, you know, you are seeing or what the client saw, okay? And they're not changing it. This happens a lot. The changing of items happens a lot with the lamps. The lamps, the chandeliers, you know, it happens a lot. You go, you see a chandelier, and then all of a sudden they come and they change it, okay? They cannot do that. The contract and the law states that what you see, what you get, okay? You cannot have a chandelier, like a very nice chandelier, and all of a sudden you get there and the chandelier is gone, and they replace it with a fixture, you know, that doesn't have anything to do with the previous one, okay? Even if the appliance is better or is newer than the one that was there, they cannot replace. So my recommendation, if you have a situation from the beginning, because sometimes you could tell that a situation may arise because of this, describe it as much as you could. There are addendums for that. You even have a blank addendum that it doesn't even have anything. You could even write whatever you want. Describe it, or videos, pictures, you know, as of record that how it was whenever you inspected the property or your client inspected the property.
Excellent answer. So going to the line 24, where we gonna write down the following items are excluded from the purchase. What do we write down? And then depending on what is showing on the MLS, or if it's the listing agent telling you that this is not included, how do we go about that? It has to be in writing. How do we go about that?
Yeah, the reality of it, if it is excluded and you're seeing it when you get to the showing, you need to exclude it, okay? So it could be that you see it in the MLS. The proper way is for them to include it in the MLS from the beginning, okay? That's usually what I'd recommend to you guys that do seller representation, okay? If you're a listing agent and your client is telling you, I'm not including the microwave, for example. Let me give you a very good example. I am not including the Nest thermostat because that's, you know, it costs $100 something. Okay, I am not including it. When the showing is done, the thermostat, the Nest thermostat, okay, is there, right? So exclude it. You need to exclude it because if it's there, they're seeing it, they want it. Okay, remember that. So you exclude it in that line, in line 24. One of the things that you would exclude is the Nest thermostat. That way, the buyer knows that as soon as he closes on the property, he has to go. And he has to go ahead and install a thermostat. Remember that in Florida, we have a lot of issues with humidity, okay? So this has actually gone to litigation. Buyers buying out of state, finalizing everything out of state, and then all of a sudden they get to the property, the thermostat is not there, and then, you know, the property is suffering from mold or whatever it is, you know, or is close to that point. So exclude it, write it down. If you're a listing agent from the MLS, include it. Repeat it again in the showing, and that's not enough. Include it in the contract.
So it's very important that when you get a listing, go about with your seller about what they don't want to include. It happens to me. The last listing that I have, they don't want to include the security system. They have a bunch of cameras in the house. They're going to take all the cameras. But at the time of showing, there were all the cameras. Everybody asked for the camera, and you have to say on the seller property disclosure that a lot of people, I don't know, for some reason, they don't use the seller property disclosure, but it was included on the seller property disclosures, that the alarm system is not included on the cell, and none of the cameras are included on the cell. But it was in writing. I have it on the seller property disclosure, so I can hand the seller property disclosure to anyone that is writing an offer on the listing, and they know that it's not included. So it has to be, it was on the seller property disclosure, and it was also on the offer from the buyers. Put it in writing, because I mean, like Inalvis said, if they see it, they want it.
Yeah, in writing. Your goal, and by the way, when I say in writing, I'm not talking about WhatsApp. I'm not talking about text messages. I'm talking about in writing in the contract, because you know that's something else that happens a lot. And remember that in 2021, when the contract changed, WhatsApp is not a way to give notices from one party to the next one, so it doesn't regulate. Text messages do not regulate anymore. Writing means email, or a communication via fax, handwritten, whatever it is, but no WhatsApp, no text messages, and definitely this is something that not even via an email. You put it in the contract, okay, on an addendum to the contract. Otherwise.
Excellent. So going back to, I think we have a lot to cover, but going down, and we're going to go to the purchase price now, and the initial deposit on cash transactions. Inalvis, what's customary for the cash transaction to be the initial deposit?
Yeah, the initial deposit, remember, technically speaking, you do not have to have a deposit. So keep that in mind, okay? The key here is, who do you represent? If you represent the buyer, the less deposit that you give, the better for the buyer, because remember that the deposit is what's online, you know, for the buyer. If you represent the seller, you want more deposit, okay? Having said that, don't go to the excessive route either, because you know a lot of people ask for deposits that they're excessive. So there's kind of like a rule of thumb that people follow, which is kind of like 10% of the purchase price. In my opinion, as an attorney, that might be too much when you represent a buyer in specific circumstances, okay? So keep that in mind. Who is your client? And remember that for the buyer, my recommendation is, if they're asking you for a higher deposit and the buyer is willing to do the deposit, that's okay, but don't give one deposit. Do an additional deposit, break it in two, okay? So what you do is you put a deposit at the beginning of the contract. Usually I recommend within 3 to 5 days after the execution of the contract, okay? And then the second deposit, the additional deposit, will be given after the inspection period, okay? That way your buyer knows for sure he wants a property and they're gonna go ahead and give the deposit, okay? Remember that the deposit is the tool that the seller has to tell the buyer, if you cancel, I'm keeping the deposit. So the less money that you have as a buyer, the better, okay? You don't want a buyer buying, I don't know, a $150,000 transaction with a $50,000 deposit, okay? That's excessive. You don't want that. Okay,
Right.
but a $50,000 deposit, for example, might be a good deposit if the buyer is buying a $1 million property. Okay, so keep that in mind. Who do you represent? That I think that's the key here, not the amount.
Okay, excellent, excellent. So the deposit, it should be made with the offer, or it should be made after the offer is being accepted and becomes an executed contract?
Okay, it all depends when is the offer accepted, okay? Because for example, if I'm working, and this happens a lot in the industry, if I'm working on the offer on a Friday afternoon, Friday late, okay, I cannot have a deposit that accompanies the offer, because Friday late, banks are already closed, the title company is closed, everybody's closed. Before, we had the electronic version of the contract, and we used to travel with the contracts, blank, to fill it out by hand. At that point in time, the deposit accompanying the offer was very convenient, because you will meet with your client, you will pull out the contract, and then you will fill it out by hand, and they will give you a check. Okay, so it was possible. Nowadays, even though we have electronic and we have everything like now in the computer, it might be tougher, because now you're not getting that check from the client. Sometimes you're not even with the client when you're preparing the offer. So keep that in mind. It depends. If you're working on the contract Monday morning and they're going to go ahead and sign it Monday morning, then accompany the offers is doable, because they could go to the bank, or they could give you the check, you could get it to the title company. But if that's not the case, then give your client time to send the deposit. Give them, usually what I do is 3 days, but keep that in mind. If you're working over a weekend, then you have Monday off, okay? Always keep that in mind also. You don't want to start a transaction where your client is defaulting for not giving the deposit on time, okay? Keep that in mind.
Okay, I understand. Excellent. So we're only on the first page and we have more to cover, but it's very important, because these are questions that the agents ask all the time. So they have to express a percentage or an amount of money when you had a financial transaction. Either that they put the amount of money or the percentage. What's in order to get more protection, is any difference between one or the other? It doesn't matter.
No, that's a very good point, and something that I was discussing with somebody from financing the other day. You could include amount or percentage. The thing is that if you include percentage, okay, remember that it's going to be the percentage based on the appraised value. Okay, so there's room for that percentage to change. Okay, you could go up and down. If you put a specific amount, okay, and the client cannot get that specific amount because the appraised value came lower, it gives me certain flexibility for me to say, hey, my client was not approved. Let's say that we put 500,000, okay, and it only got approved for 485 because of the appraised value, right? My client did not get the $5,000, the 500,000 that the contract states. So it gives me as an attorney some type of room for me to, tell the seller, it didn't get approved for 500,000, we could cancel the contract. Okay, but having said that, either or is fine. Okay, most of the times we're not in this position, and then I also need to have some other background or some other support for my argument that I didn't get the 500. Okay,
I got it. Excellent. So basically, okay, I'm gonna leave it like that. So on the balance, you have to write down the amount that they have to bring at closing, correct? After the
usually the good thing is that you don't have to do much math, because usually the programs that we use, it gives you the balance automatically, but you should definitely include the balance. So that would be the amount that they need to bring at closing. Remember, because sometimes buyers see that amount and they say, oh, good, that's the amount that I'm going to have to bring. No, they have to be thinking about closing costs also, okay? Correct. In addition to that amount.
Correct. Excellent. All right. What's customary for the time of acceptance of the offer? 48 hours?
Again, 48 hours is a good time. 72 also might be a good timing. It all depends on your client, okay? If you have a buyer that is, we have buyers that they're in a rush, you know, and they want to know and they want to get answers about the contract right away or the offer right away, then 48 hours might not be enough, okay? You might want to do 24, but in my personal opinion, I think 48, 72 hours. And the reason being is you send the offer, the seller has to probably review. Some sellers come and tell you, you know what, I am not going to review one offer at a time. I'm going to review an offer within 2-3 days. Okay. So that's another key point that we had to discuss. You need to know from the listing agent, how are they doing it? Because if they're telling you, you're going to send me the offer today, Monday, but I am not going to review it until Friday, you have to tell your buyer, are you willing to wait to Friday for them to review it? And if the buyer says yes, then your time for acceptance is not going to be 48 hours. It's going to be all the way to Friday. Okay. Otherwise, your offer is gonna die and they might not even look at it. Okay. So keep that in mind. It depends on the transaction, the needs of your buyer, and how is the seller going to evaluate the offers.
Excellent. So just to clarify, the effective date, what is it?
Yeah, the effective date is the day that the last party signs the contract, or, you know, initials the contract if there's a counter offer, and the contract is delivered. Okay, so what do I mean by that? I could sign the contract today. Let's say that I'm the seller, I accepted everything and I signed it today, but today is Sunday. And I completely forgot that I had to send it to the buyer, okay? If I don't send it to the buyer has no way of knowing that I executed the contract. So that would be like a one-sided type of situation. I know, but the buyer doesn't know. So I need to make sure that I go and I deliver the offer to the buyer. That means that if I wake up Tuesday and I go, oh my God, I forgot to send it to the buyer, then my effective day is going to be that Tuesday that I send it to the buyer. This is important, okay? Very important. And you guys as agents have a way to control it more than me as an attorney, okay? Because what happens to me is that I usually get the contract for you guys. And sometimes you tell me, oh, the effective date, they signed this date. The question is, did they sign and deliver that date, okay? You might be cutting time from your buyer if they sign one day and they deliver the next one. Okay, so think about signatures and delivery. Once there's delivery, then it's two people on the same page. Okay, the buyer and the seller.
So for inspections, for example, you have 7 days to do inspections and to cancel if you don't want to keep the property. So they sign it today, but they deliver tomorrow. So tomorrow is when it's going to start the clock ticking for the inspection periods and all the other dates in the contract, correct?
Yeah, absolutely. It's going to be tomorrow. It's not going to be today. If you're counting today, you're doing a disfavor to the buyer because you're giving the buyer one less day. Okay.
Excellent. Excellent. So moving on, we're going to the closing date. On the closing date, should I include on or before the date that we want the closing? And what's customary on a finance transaction? 30 days, for example?
Yeah, customarily, let's say that you have a 30-day financing period. Typically 10 more days for closing, 15 more days for closing. Okay, that's when you're financing. To give a certain, you know, like assurances or certain freedom to the buyer to get the approval from the bank and then close. Okay, so financing 30 days. I will put a closing 10 days after or 15 days after, okay? If you're doing cash, then this is completely another story because cash transaction, you know, they're faster. So typically, what do you need? You don't have a bank, so you would need everything from the title company. And then what is the timing from the title company? Okay, how much time do I need to be able to close? Okay, typically speaking, I could have everything ready within 15 days to 20 days. Okay, if everything goes
after effective date.
After the effective date. Yes. My recommendation is always try to get 30 days, okay? Just in case there's some type of complication with an association, stoppals, things like that, okay? And always keep in mind, even though I might be able to do the closing within 15 to 20 days as a title company, remember that if you are within a condo or within an association, okay, then I need condominium approval or association approval. And I cannot control that. No matter how many times I call an association as an attorney, I think that's one of the scenarios that they tell me, you know what, Ina, I don't care that you're an attorney. It takes 30 days, it's going to take 30 days. So you have to think about that and keep that in mind.
So in condominiums, we have to be very careful because, I mean, you can be out of contract, basically waiting for the condominium association to give you the approval.
Absolutely.
And that's excellent. So moving along, on extension of closing day, when you have a finance transaction, automatically you get 7 days.
Yeah, well, it doesn't work that way. Yeah, you have to know the conditions that are going to get you to the extra 7 days, or the additional days. The clause states that it has to be, or it's only going to be in the situation that your closing day is today, for example, and you still, or you get the clear to close from the bank today, but the bank tells you you're clear to close, meaning you could go ahead and do the closing, but wait a minute, I have federal requirements, FDC requirements, that tells me, bank, you need to send the disclosure to the buyer today, but you need to wait 3 days, okay? So if that's the scenario, today clear to close, bank has not been able to send the CD to the buyer, and now they have to send it today, by law, they have to wait 3 days, and we cannot break the law. Because of that, if you are in that situation, then you could use the clause, and the clause stays as follows. You have up to, not 7 days, up to 7 days, okay, to close. The closing is going to be extended automatically up to 7 days. What does that mean? If the lender comes and tells you, I could close it in 2 days, that's going to be the day that you need to close it, the 2 days. If the lender comes and tells you it's going to take me 4 days, then it's going to be extended up to 4 days, okay? So keep in mind that it's not automatically 7 days, it's up to 7 days. The moment that the lender comes and tells you, I'm ready, you need to close it, okay? But definitely this is a clause that, to me and to many of you agents of Canvas, which, you've been in the position, it helps a lot, okay? It helps a lot because we've been in a position that the seller does not want to give an extension. Bank gives it clear to close by closing day, but then we had the situation of the 3 days, okay? And we cannot break the law. We have to give the 3 days.
Okay. What happens when you have an approval, but it's a conditional loan approval, and then there's some condition that needs to be met in order to close, and those conditions are not met? What happened then?
Okay. This one is a good one, and it's something that happens a lot. And the first thing that I have to say, and it's a reminder of everything that I go telling the agents in every single class, is that during the financing period, work with a final approval, not with a conditional approval, okay? If you had 30 days, let's think that we have 30 days to get full approval, okay? And I think Leo could also help me with this question, okay? Lenders sometimes give you a conditional approval, but they tell you you're approved subject to ABC, okay? So you go and you tell the seller, I'm approved, look at my commitment, right? But then all of a sudden, the buyer could not produce number C. Nowhere, they couldn't produce it. They couldn't find that. It's impossible to produce it, right? That gives to the lender the ability to cancel the approval because you didn't meet the condition. You had to meet your conditions to get the final approval. Okay, so now you're in the position of, oh, I was approved conditionally, but now I'm not approved. So how do I tell the seller? Okay. As long as you are within the financing period, let's say that is 30 days, as long as you are within the 30 days, it's not a problem whatsoever, because you could cancel at any moment but remember, denial from the lender. So if the lender told you you were approved conditionally, now you're not approved, all I have to do is go ahead and get the denial from the lender and send it to the seller because I am within my inspection period. Okay, no problem whatsoever. The problem arises when we work with a conditional approval, okay, and we let the 30 days expire, okay, and now we don't have the financing period, okay. The lender could come and tell you, you're not approved, I'm removing your conditional approval, okay, you're not approved anymore, and now what do? because you did not extend the financing contingency period, okay? Now the buyer is gonna be in the position of, I'm not approved anymore. I have to do two things. If I don't want to lose this transaction or lose the deposit, I'm gonna have to go and close in cash, okay? Tell a buyer to find $450,000 in cash. Not every buyer has that money in the bank. That's the reason why they went and they got financing, okay? Or then now we're in the middle of a dispute because now the seller is gonna tell you, buyer, I do not care. You told me that you were approved. You know, your financing period expired. I do not care. The deposit is mine, okay? So this is very important. Keep it in mind. As long as you have the financing contingency period active or alive, it doesn't matter that the bank comes and tells you you're approved. Now you're not approved, but you need to have the security that it's alive, that period is alive.
So right now that we are in the tax season, and one of the conditions could be to present, any amendment to the taxes or whatever situation, or with the taxes, the IRS take forever. It's a good idea to recommend to your buyer to extend the period to be protecting that buyer.
Absolutely. Absolutely. We need to be aware of our surroundings. We need to be aware of what's happening, around us. And right now, Leo said it, tax season. Right now, lenders could come and easily tell you, you need to file taxes. I need to see your 2022 tax returns, okay? So definitely, this is something to keep in mind. This is something for us to absolutely, I'll go ahead and request an extension of the financing. And when I talk about extension of the financing period, let me make another point here that I always run into trouble with the contracts. You have to extend the financing period, not the closing date. Sometimes you're trying to get a financing period extension and you bring me a closing day extension. That doesn't help me, okay? Other than the fact that the closing is extended. You need to get financing contingency extended. If it happens that you have a closing day, okay, that is very soon to the financing, let's say that I have financing today and I have closing in 2 days, then you need to get 2 extensions, financing period and closing day. But do not go and extend my closing day, and don't extend the financing. You're missing the purpose, okay? Keep that in mind. 2 different deadlines. 2 different deadlines with 2 consequences. You don't meet the deadline, different consequences, okay? So definitely right now it's a very good recommendation for them to keep in mind that it's tax season and they might request tax returns and keep that financing period alive. Absolutely.
Okay, excellent. And one suggestion is when you're working with a buyer and you get the initial documentation, if you can have them go to the IRS page and get the transcripts, if they file the taxes already, that's going to save a lot of time. Because if the lender waits for that to the end, then you're going to be an issue. You're going to have an issue with that, and the time is going to be against you. Okay, thank you. Now it's going on now to occupancy and possession. What happens when the property has a lease in place or no lease? There is a tenant in place, it's month to month. And how do you go around that? How you present that when you present the offer? How do you go around that?
Yeah, the question is there going to be somebody living in the property after the closing? And when I talk about somebody, is a tenant, okay? Either because they have a lease or they're month to month, as Leo mentioned, okay? So if let's say that the answer is yes, then to your buyer, is this something that you want? Okay, do you want to go ahead and continue with the tenant? It might be that the buyer is buying an investment property, okay, and they want to continue with the tenant because that's the attractive thing about the property. They have an income already, okay? But it might be that your buyer is buying the property, to live in the property, and guess what? He's getting, let's just throw it out there, he's getting an FHA loan, okay? You're very limited. You cannot have that tenant after the closing, okay? So this goes with my saying, know your client, okay? Know your client. It's never, the information that you get for your client is never enough. So know your client. If your client tells you, Ina, yes, I want the property with the tenant, then what we need to make sure that we do is that we go ahead and indicate in clause 6 of the contract that there's a tenant. How do you do that? By marking B. Okay, marking B. When you mark B, that means that the buyer is getting that property, okay, buying the property, assuming that the lease, and therefore, because they're assuming the lease, it comes with the tenant, okay? So tenant is gonna remain in the property after the closing. If your buyer tells you, no, I do not want the tenant, or I cannot have the tenant because of the type of financing that I'm getting, or you know, my purpose with the property, which is to live there, then you cannot select that, okay? You cannot select that option. You leave it blank. And that means that the seller has to go and do whatever the seller needs to do to give the property free and clear from the tenant to the buyer, okay? But think about this. This might be complicated, because the same way that the buyer and the seller are entering into a contract, the seller has already a contract with the tenant, okay? That he cannot easily break the contract. It doesn't work that way. You cannot have a 1-year lease with somebody and tell them on month 2, get out. It doesn't work that way. You know, there's certain obligations and rights that the landlord has and the tenant has, okay? So keep that in mind. Is it gonna be possible or not? This is something that you need to have that conversation with the listing agent, okay? If they tell you, yes, it is gonna be possible because my lease agreement has a clause stating that I need to give 30 days notice and they will leave, then great, you know, you could buy the property like that. And still the seller is gonna have to make sure to get the tenant out of the property. If they tell you, no, you cannot do that, then the seller is placing a position where they have to negotiate with the tenant. And usually the negotiation leads to, okay, tenant, let me pay you let me return the deposit, let me return the last month, and probably let me go ahead and give you some money for you to get out of the property, okay? With the rents, how they are right now, and you know how crazy they are because you are in the market, okay? You're real estate agents, that might not even be something as easy to do because, you know, the rents are very expensive. And you don't find properties to lease like that, you know, super fast. So be careful with this one. So to recap, if you market, if it's marked, 6B is marked, buyer is buying the property with the tenant, okay? There's a tenancy onto whatever month that the buyer is assuming. If you leave it blank, okay, no mark, then the seller has to go ahead and give the property, surrender the property to the buyer without the tenant. Doesn't matter what the seller has to do. If the seller has to file an eviction because it's a month-to-month tenant, the seller is going to have to do it prior to closing. If the seller has to negotiate with the tenant, the seller is going to have to do it before closing. But keep that in mind because sometimes we talk about the buyer all the time and we're not thinking that we represent sellers all the time, you know. So this is key. If you leave it blank, seller is obligated to get the tenant out of the property.
So basically, when someone is buying the property with the tenant, they had to go by the lease agreement that the seller has with the tenant. And when you're financing a property, if you're buying as a primary home, you need to move to the property in 60 days. Yeah, so if you have someone that has a lease that expires 3-4 months from now, it's not going to work unless the seller works something out with the tenant and have them move, you know, maximum 60 days after the closing date.
Yeah, absolutely. Yeah, absolutely. And even like that, let's say that the seller works something out with the tenant, there's always a risk that the tenant is not going to go out, get out, okay? And then what's going to happen? Pretty much the buyer is in a way buying a lawsuit because they had to file an eviction of the tenant, okay? So this is very important, very important.
So there is no chance that you're buying a property and you're raising the rent on a tenant that has a lease already. It's protected by the lease from the seller.
No.
You cannot do that. That's a no.
No. They cannot do it if there's a lease agreement in place. Remember, it's like the buyer is stepping into the shoes of the seller. So that's why during the inspection period, the buyer should review the lease and make sure that the rent that the seller is collecting is the rent that the buyer wants. But they cannot just simply say, I'm the new owner, I'm going to raise the rent $1,000 if there's a lease agreement. Doesn't work that way. Okay. Okay. That's also very important and a very good point.
Excellent. Going to number 7, we're running out of time. What should I check when I'm not going to assign the contract? I may not assign the contract. And how can you explain that? What is assign a contract? When can I assign the contract? When I cannot assign the contract? Can you explain that, please?
Okay, sure. Simple. You have three options. Okay, you have the first one, and the second option allow the buyer to assign the contract, but they have a difference. Okay, and let me, before I explain that, let me tell you what would be the situation that you're assigning a contract. Okay, for example, an investor. Okay, let's say foreign or even somebody here in the United States. I'm buying an investment property. You know, my recommendation is always, as the corporate attorney, you do it with a company. You don't do it in your personal name. But then the issue that I get all the time, but Ina, I cannot wait. I need to submit the offer. I cannot wait until I have the company ready. Doesn't matter. You could continue to get into the contract. How do you do it? They say that I'm the owner of the company. I put Ina, Zubiaur, and or assigns, okay, as the buyer. Remember, and or assigns. And then I go to clause 7, and I have to select either option 1 or option 2. Okay, what is the difference? Option 1, if I select option 1, that means that I'm going to transfer to the company, and me as individual, remember that I signed the contract individually, and release from any obligation. The only entity, the only person that, or the entity is going to be the only one responsible for the contract. Okay, I'm off the hook. I assign, now is the company, that's it, I'm done. Okay, me as an individual. Okay, if I select number 2, then all I'm doing is the company is going to be obligated under the terms of the company, the contract, but I am also responsible. I am liable. Okay, so why does that happen? Okay, usually sellers do not want assignments to happen easily. Okay, why? Because if I could assign a contract, I could go and say, you know what, Leo, I cannot qualify for financing. You know, I don't want this property anymore. I'm going to assign it to you. And then I'm assigning it to somebody brand new that didn't have anything to do with the transaction. Okay, it used to be also a time where people would say, you know what, I got into this contract with this offer and this transaction that it has a very, very good price. I'm going to go to Leo and I'm going to tell Leo, you know, Leo, I'm going to assign to you if you pay me $10,000. Okay, so I am getting a benefit from assigning that contract. That's why sometimes sellers do not like this. Okay, they don't like the assignment. So what are some sellers willing to do? They say, okay, I'm going to let you assign, okay, but you are still responsible. That means that if now Leo, I assign to Leo, and Leo breaks the contract because he goes, no, I couldn't get financing, my financing period expired, I'm breaking the contract, that means the seller could come after me, okay, which was I was the original person in the lease and the contract, and after Leo, okay, that's option 2. That's the one that sellers like the most. Okay. Option 3, no assignment whatsoever. Don't even come and talk to me about it because I don't want the contract to be assigned. Having said this, a lot of contracts have option 3 selected, and afterwards you go to the seller and you tell the seller, look, the assignment is going to be to my company, and the seller may allow it. Okay. So don't close your minds to the possibility this is not happening. You could still try it. You know, especially when you represent the buyer, you could still try it, okay?
And everything is negotiable on the contract. So
yeah.
So
Everything
this I see this a lot with investors, a lot of wholesalers that they purchase the property and they don't close on the property, that they do double closing and they flip it, you know, the same day. Anyway, we're moving on. Financing now, and there's a couple of questions there. I don't know if you want to jump into the questions now or you want to wait.
It's up to you. We could answer the questions.
Marlene is asking me. She wants to participate. The first one says, how do we should write the address when buying a multifamily, since it has different property numbers, but in MLS there is just like the main number? That's weird because a multifamily, if you have a fourplex, for example, is one address with different, I mean, number 1 or A, B, C, and D, right?
Yeah, you're gonna have to go to the property records and see how it's reflected. Sometimes you have one address, exactly as Leo is saying, and it's telling you 1 through 6, I don't know, or 1 through 4. You know, sometimes you don't have that. Sometimes you have 1920, 1922, 1924, 1926. And then you would add exactly like that, you know, 1920, 1922, 1924, 1926, Northwest 41st Street. to give you an example, you know. But the thing is that you have to go to the poly records. You have to see how it appears in the poly records, okay? I think that's going to be your guide.
It could be also that they have different folios. If they have different folios, they're different properties. It's not a multifamily, it's a different properties.
Absolutely.
So you're buying different properties. No,
yeah,
not
you
a
include all
multifamily.
the folios. Make sure you include all the folios and you include all the addresses, okay?
Got it. I hope that answered the question. The next question is what if all but one document is executed? Is the effective date when the last document is received?
Okay, if that last document that we're talking about is a document that was attached to the contract, let's just pick one, condo writer, okay? You're creating the offer, you sign the contract, the condo writer is marked in the last page of the contract as one of the attachments, and now you don't have it signed, okay? If it is supposed to be attached to the contract, yes, it's the date that that addendum or that execution is, document is executed. But having said this, let's say that you have the contract and you sign the fully executed contract today, and you're getting that condo writers 5 days from today because I called you and I told you, get it as soon as possible, because if you went to my class with condo writers, you should know that now you have a defective contract, right? Because it wasn't attached. So let's say that I call you and I tell you, get it ASAP, and you take 3 days, 4 days, 5 days to get it, that's not going to affect the effective day of the contract, okay? So I'm talking about the situation, you have contract and right now you're working on the contract, they send you the contract back, but they tell you, I'm going to send you the condo writer in a few minutes, okay? And they send it to you the next day, then that will change the effective date. You did not have a fully executed contract at the point that they send you the contract because there was an attachment, okay? But if it's 5 days or 6 days, it's not going to change.
So it's very important when you write the offer, all the attachment that you're going to include on page 11, you have to mark those addendums that are going to accompany the offer.
Absolutely.
And they all
you need
have
to get all of them.
Right, and they all have to be executed and effective on the same date. If not, it's not the effective date until the last one has been acknowledged, basically, have been delivered and acknowledged.
Absolutely. I mean, as a matter of fact, look at what happens. If you had the contract, let's say that you had 3 addendums, okay? And you had them marked in the contract. If you get a fully executed contract today, but you miss one of those addendums, you technically do not have a fully executed contract. You have a contract that is null and void, okay? That's why I'm making the comment. You could have a contract, and it happens a lot, unfortunately. You could have it today with the 2 addendums, but you're missing one. If they send it to you tomorrow, okay, which is a short period of time, that will move the effective date to tomorrow. But if I call you, I have to call you and tell you, hey, your contract is effective, get me the addendum as soon as possible, then that's something else, because now it's taking days for me to tell you that, okay? So keep that in mind. Keep in mind that everything all the addendums have to be attached to that contract.
Excellent. It's 12 o'clock. I had another question from Marlene. It said, I have a quick question that just came up regarding effective date of contract. If contract calls for 3 addendums and was submitted with the offer, is the effective date? Well, we answer just that. Upon delivering on the fully executed addendum or just a contract, you just answered that. It has to be all the addendums that are accompanying the contract. It has to be executed, signed, and delivered in order to be executed, the full executed contract, correct?
Yeah, absolutely. Unless you start working with the transaction and you realize, like 3 days after that you're missing one of them, then that's not going to change the effective date. Okay, but you need to get that addendum as soon as possible because that contract that we're working with, is effective. It's missing something.
Mary asking, is the listing agent allowed to ask the buyer's agent to have the buyer to fill out an application with their lender, even if you provided a pre-approval and say they can call the buyer's lender with any questions?
Okay, the key to that answer is the financing contingency clause, okay? You have to keep in mind that with the new clause, I mean, and I keep saying new, because it was in 2021 October, but the new one gives the seller, and when I say the seller, listing agent, the ability to keep asking you or for either updates about the financing or, in this case, the application, okay, about the financing, which brings me to another point also. If that happens, you need to reply, okay? And you need to give the information that they're providing to you. With the application specifically, you have a deadline for application, which is the 5 days, okay? If you have that deadline and they ask you, show me proof that you apply within the 5 days, you should provide proof that the application took place, okay? Because you're trying to prove that you met that deadline.
I see. Marlene is asking whose responsibility is to complete the first right of refusal clause of condo rider.
Who's okay? That one is a complicated question. The condo rider, okay, should be filled out by the seller, in my opinion. Okay, what happens? The condo rider, okay, the HOA always should be filled out by the seller. And remember that the key is that the seller should give it to the buyer before the buyer executes the contract. Okay. And going back to the condo and HOA riders class, okay, the condo rider should be filled out by the seller. The problem that we have all the time is that when you're submitting the offer, you have to attach a condo rider, okay? And the question is, Ina, I had to attach it because you're telling me that if I don't attach it, I might have a defective contract. Absolutely. So what do I do? Okay. Two recommendations I have. Either you go ahead and fill it out. And how will you fill it out if you don't have the information? Okay. Think about this. If I go and I put that it does not have a right of first refusal, and then it has a right of first refusal, I will be doing something incorrect, okay? Because I will be lying. So what I usually do as an attorney and what I recommend, if you don't have the information about it, okay, either include that it does have a right of first refusal. And when you send the offer, go ahead and put a note in your email to the listing agent, telling the listing agent, I fill out this information, but you need to confirm that it's correct. Or two, okay, you attach the condo rider, you leave in blank the information that you do not know, leave it in blank, okay, and send it to the listing agent and tell the listing agent, you need to fill out the information that I'm missing in the condo rider, okay? But the key here is that when they send it back to you, okay, is at that time, remember that you had to present it to the buyer for the buyer to then accept it and include their initial next to the changes, okay? So two, either you fill it out to the benefit of not lying. It's better to put it does not have, I'm sorry, it's better to put that it does have a right of refusal, which most condominiums have, and then that including does not have, and then it does have it, and then you'll be lying. So better to put that it does have a right of refusal. Send it to the listing agent with the offer. Make sure the listing agent approves and confirms. Or two, you leave it blank. You send it to the listing agent regardless, and you tell the listing agent, remember that we're not going to have a fully executed contract until your seller or you confirm this information, fill it out, and you send it back to me. And when you get it back, remember that you have a counter offer because now they made a change, probably by hand, okay? Including that information, have the buyer initially.
Excellent. Inalvis is 12:05. It's been an hour. We're on page 2. What time do we have? If
no,
we have.
I don't. I mean, if you want to go ahead and finish, I don't mind finishing. If you guys want to go ahead and break it and then do a second part, that's fine with me. I think it's all gonna depend on the agents that are connected with us, how much time they have, or if they want to go ahead for us to continue, or maybe we could do a second part. It's up to you guys. For me, I mean, I don't have. I have time. You don't have to worry about me.
It's been an hour. I don't want to take too much of your time. So number A, we have financing, which I know a little bit about that, but let's go with financing and what are the provisions on the contract. So we always have to select if it's a cash transaction or financing, and here is very important that we put the dates on it, like you were talking about. For example, this contract is contingent upon within the days after effective date that we need the buyer approval and the type of financing. The only thing that we suggest to leave blank is the interest rate, because that's not going to be, it's going to be depending on what, at this point, we might not even know what would be the interest rate for them. But other than that, I mean, what down payment, the type of loan that they qualify. But when we write an offer, ideally, we should have a pre-approval letter and a DU approval already. So I don't suggest anyone to write an offer if you don't know if your client is being pre-approved and fully approved by a lender with all the documentation in place. We have the credit report, we have the assets, the income, everything. So you don't, you know what you're dealing with. So don't write an offer, like going blind. You don't know what type of client you have. So in financing, anything specific that you want to make, you want the agents to know what they should and what they shouldn't do in here?
Yeah, I agree with you. You would never, I don't recommend you start working with a buyer without the buyer being pre-approved, because then you might be wasting your time. And then the other thing about it is that when you submit the offer, the seller is going to tell you, where is the pre-approval? Where is the DU? Where is, and Leo could probably, help me out with this one. I do not recommend, because anybody could play with a DU. That's the ideal, I would want, like an approval, like done correctly with somebody that is serious about providing the financing, and that they do it correctly. Okay. So keep that in mind as well, because nowadays you could go to 3 different mortgage brokers, 3 different banks, and they might not even be serious about it and give you a DU. Okay. So understand the DU. Sometimes we get the DUs and we don't even see them, understand them, because you might be wasting your time. And at the end of the day, in real estate transactions, time is key. You're going to take your time. The commission is going to take time to come. The work that everybody's going to put into it, it takes time. So you don't want to go ahead and start the transaction, without you having security that the buyer is pre-approved. Okay, so that's one. And then 2, with the financing, I think that I cover my main point already. Work with a final approval. Those 30 days that you include there, nowadays you see 20, you see 30 days. Work with a final approval. If you're accepting less than 30 days, 20 days, 15 days, I have even seen contracts 10 days that I have sent back, which is crazy. You need to know who you're working with. Who is your lender? Are they going to be able to go ahead and give you what you need in 20 days? Okay. That's key, because otherwise you're going to end up having to ask for extensions, and you might be in a position that the seller is not going to give you the extension. Okay. Remember that the seller could come in the 20 days and tell you, no, I'm not going to give it to you. And then you will lose your time. So know who you're working with. Sometimes people call me and tell me, Ina, they're giving me 15 days and I told them do not accept it. And then they tell me, no, but my buyer is working with whoever, And then my question is that person serious enough that they're going to provide to you something in 15 days? Because the person giving the financing might not be, So keep that in mind. Second thing that you have to keep in mind, remember that now the financing contingency is approval from the lender. Okay. And this takes me to a point that is highly debated, but appraisal satisfactory to the lender. It's not satisfactory to me. It's not satisfactory to the buyer. It's not satisfactory to the seller. It's satisfactory to the lender. And guess what? The contract doesn't have anywhere a definition for satisfactory to the lender. Okay. And this is something that I talk to lenders all the time. And Leo is here. Leo could even give me his answer. What is satisfactory to you? It might be that I have an appraisal that is $5,000 less. Okay. But I know the buyer has money in the bank. That might be satisfactory to me. It might be that that same appraisal, okay, with $5,000 less than the purchase price might not be satisfactory to Leo. Okay, so what is satisfactory to the lender? That I think that's part of the dilemma, with this contract and this clause. And then it brings me to the point of that I always tell in class. I was trying not to get to that point because it's very heated. It brings me to the point, what does your buyer want? Because if your buyer is okay with me telling them the appraisal is satisfactory to me, you have to bring $5,000 to closing, okay, more, because I know you had the money. If the buyer is okay with that, then we're good. But if the buyer tells me, Ina, I am not paying $1 more for that property, than purchase price. Then I'm gonna have an issue. Okay, and why do I have an issue? Because the bank is telling me you're approved and accepting the appraisal, but you have to bring $5,000 less. Okay, you're fully approved, you're fine. I mean, let's say they even have a final approval. Now the buyer is in the position that they have to give the 5,000 less. You cannot cancel the contract, okay? Unless I have an appraisal contingency, which is the heated part of the argument, and the sellers are not accepting appraisal contingencies nowadays, so you cannot fully protect your client or your buyer because the sellers are not accepting it, okay? So this is something that you definitely need to discuss to your buyer, with your buyer, and explain to them, and I know it's hard, that satisfactory to the lender might be that the appraisal comes for a little bit less, and the lender accepts it. Because I cannot tell you that satisfactory to the lender nowadays is an appraisal coming at a purchase price. Okay, it might be, it might not be. The lender might approve, or the lender might not approve. Okay, so keep that in mind with the financing.
A question that I get all the time is, do I need to write an appraisal contingency addendum? If it's in the contract that if you're financing, part of the financing is you need to have an appraisal. It's on the contract already. But if let's say that the appraisal comes low and the buyer doesn't have the funds to come, we have a problem. We have a problem.
Yeah.
And another thing for the listing agents, if you have a buyer that sent an offer to you and you have a condo and they say they can close in 21 days, it's not going to happen. Don't take that offer, because they're doing that to get your seller out of the market. They can take the contract and then they're going to ask for an extension for sure, because no condo will close in 10 or 21 days, because just association, they need, even if you send the condo docs to the association to fill out the condo questionnaire, and they're going to take more than 10 days for sure. So if you're a listing agent, you have a condo and someone makes an offer to you to close in 10 or 21 days, even in cash, you're going to have an issue with that. Okay, so be aware of that. Okay, anything else in Inalvis on financing, so we can move on?
No, we could move on. I think we
Any
can move on,
questions?
and then if there's questions, we could get the questions.
All right, excellent. Any questions? No questions. Okay, let's go. So going to number 9, closing costs, title insurance, survey, home warranty, special assessment, cost to be paid by seller, cost to be paid by buyer. On the contract, it states who should pay what, correct? And especially now with the special assessments that we have all around South Florida with the condos, it's very careful that you have very clear, if you're presenting your seller, to have that they know what assessment are coming to them, because we have an issue with one of the agents that they have to do an extension because the seller claims that they didn't know that they have a $15,000 assessment, and then they want to pass that to the last minute to the buyer, and the buyer start backing out saying, oh, no, I'm not taking that. That's your assessment. You pay for that. So we have to be very clear. Any suggestions on that?
Yeah, absolutely. First of all, if you let's tackle the special assessments, okay? Special assessments for a condominium or an HOA, you have to make sure that you include those in the condo rider if it is a condominium, or in the HOA rider, okay? Right there in those two riders, you could specifically include who's going to be responsible for paying the special assessments, okay? And how they're going to be paid. And that's key. If you have a condo rider and an HOA rider that you did not include, and I'm going to tell you, it happens, okay? You are going to be in the middle of a dispute, like Leo mentioned, trying to debate who's going to pay for what. So keep in mind, condominium, HOAs, you have a condo rider that is very specific as to special assessments, and right there you can negotiate who pays for what. And you do also have an HOA rider that is very specific as to the special assessments. That brings me to my previous point. If you have a contract that is missing the condo rider and the HOA rider, guess what? We don't know. So there's going to be a dispute, okay, if something like this comes up in the transaction. As to closing costs, is very clear, okay? Miami-Dade, Broward, you're always going to go ahead and select option 3, which is the Miami-Dade Broward provision, okay? It doesn't make sense for you to go anywhere else, okay? Miami-Dade Broward provision, what does it say? Buyer is going to select the closing agent. That's the right of the buyer, okay? That's the right of the buyer to select the closing agent, and they're going to pay for the owner's policy and the lender's policy. Normal. Seller is going to go ahead and pay for the title search and the lien search. How much are we talking about? Title search could run in between 125 to 150, 175, okay? Lien search could be approximately $250 to $400, okay? So if you select Miami-Dade Broward provision, you are already taking away 2 fees from the seller, okay? And sorry, from the buyer, which is the lien search and the title search. Now, let's talk about the other 2 options, okay? Because these are important. The first option is that it tells you that the seller shall select the closing agent, okay? So in Miami-Dade and Broward, you're taking away the right of the buyer to select the closing agent, okay? Seller is selecting the closing agent, and because seller is selecting the closing agent, seller is going to pay for the owner's policy, okay? And remember that the owner's policy is based off the purchase price. The higher the purchase price, the higher the premium, okay? Lowest, the lowest the premium. This is typically the provision in every other county that is not Dade and Broward, Palm Beach, Lee County, you know, any county.
Orange, Hillsborough, outside of Miami-Dade and Broward,
exactly.
It's customary. Yeah, not session. Number 1 is customary. So you're selling home in Orlando, let's say, be careful because that's what you're going to get.
Yeah, absolutely. And then the seller in that case scenario is also going to pay for the lien search and the title search. Okay.
Yes. Yes.
So Miami-Dade and Broward doesn't make sense that you give that right to the buyer. I mean, to the seller.
But it's negotiable.
It is.
And we have a case here recently, last week, where the seller said, no, we have to use my title company. I don't care. I pay. So, okay, you pay. Okay, we select number 1. That's fine.
Yeah. The sad part, which is what I always mention in my classes, is when the seller comes and tells you, I'm going with my company, but I'm not paying anything for you. That's the sad part. Yeah. Okay. And that's how you need to know how these clauses work and how do you negotiate. Okay. Because if you have a seller telling you, I am going to go with my attorney, I am going to go with my company, but I am not paying a dime, then I, as an attorney, I start getting anxious. Remember that I always tell you that I start shaking because what's going on that he wants to go with his attorney and he's not paying. You know, if you want that, then you pay. Okay. Right. So that's 1. 2, buyer selects and buyer pays for everything. The owner's policy, lender's policy, title search, and lien search. It doesn't make sense to select it in Miami-Dade and Broward because in Miami-Dade and Broward, you will be putting other responsibility on the buyer. Okay, remember that Miami-Dade and Broward, some fees seller pays. Okay, so keep that in mind. Okay, whoever selects the title company should pay for the owner policy. The lender policy is always going to be the buyer because it's the buyer's option to get a loan, to get financing. Okay, keep that in mind. Know how to negotiate with this. Do not accept that a seller comes and takes the ability from your client to select their title company and then they don't pay for anything. You know, that doesn't make sense. And if they insist on that, then make sure that your buyer has an attorney representing them because there might be a reason why. Okay, they're so adamant about going to their company, with their company.
Now, also keep in mind that if you select the buyer, that's going to increase the closing costs. Okay, so be careful with that because if they don't have enough money to close, then you're gonna be in trouble. You're gonna be in trouble for that. All right, moving along. Then we go to, so it's clear Miami-Dade and Broward. The suggestion is to use the Miami-Dade and Broward clause, unless you're Palm Beach or other areas of Florida, which is customary. It's negotiable, but it's customary to use number 1, which is the seller select the title company and seller pay. Right?
Yeah.
Correct.
Absolutely.
Perfect. So let's go to survey, home warranty, special assessment. You talk about it.
Yeah, survey, there's nothing for you to do there. Okay, nothing. What it says is that if a survey applies to the property, remember that in condominiums, you don't do surveys, for example. If a survey applies to the property, then the survey is going to be ordered within 5 days. Also remember, just as a reminder, that if it is a cash transaction, this is optional, okay? As an attorney, I do not recommend any buyer to buy without the survey, but it happens all the time, you know. It is optional, but remember this, it is the option of the buyer, not your option. The option of the buyer, they need to know, you know, that how the survey works, that they don't want it, and what could be the consequences. Home warranty is barely applies, okay, in here. First of all, this is the access contract. Not a lot of people have a home guarantee to give or to transfer to the buyer, but keep it in mind, you might have a seller that has it, okay? You might have a buyer that wants it. So that's something for you to keep in mind and negotiate if needed. The next one, which is highly important that I make a note of is, or that I mentioned it, is a special assessments clause. I cannot stress enough what I'm going to tell you, and this is the reason why I'm going to tell you again. This special assessment clause does not have anything to do with the special assessments of a condominium or homeowners association. Remember a minute ago, I told you, go to the writers to go ahead and negotiate the special assessment of those. That's where you're going to continue going. These special assessments have to do with governmental bodies. Let me give you a very specific example. Whoever has worked in the Keys, okay, Florida Keys, they have, I don't know how many special assessments due to the plumbing over there. Okay, at some point in time, they had to go ahead and they had to do some repairs, so they had to exchange the actual plumbing of the city. Okay, that's a special assessment that the city imposed on the homeowners in the area to pay for 25 years. Okay, closer to home, Miami Metro Mover. Okay, in order for them to build a Metro Mover, the city of Miami imposed a special assessment on the homeowners around the area because they were going to benefit from it. Okay, that's what the special assessments in this section are for, governmental bodies. Okay, not association. A lot of times we confuse special assessment from the association with these ones, and then you guys call me and I told you, unfortunately, it doesn't work that way. Okay, you have two options. You have the option of seller pays before closing, buyer pays after the closing. That's the typical option. That's the fair option, especially when you have a special assessment for 25 years, like in the Keys, okay? But you also have the ability to select the first option, which is the seller is going to pay the assessments in full at closing, okay? But there's a catch here. The seller would only pay the assessment in full if this governmental body, the city, the county allows for that, okay? If they allow me to go ahead and get the balance and collect it in full, then I'm going to be able to do that. Otherwise, the buyer is going to continue paying after closing, okay? That's what I had to say about that one. Again, it doesn't have anything to do with the association special assessment. CDD, okay? CDDs, community development districts, they're not special assessments. They appear under in the actual tax bill under the special assessment section, but they're not special assessment. The contract right now states that CDDs are treated as another tax and they are prorations. Prorations are done like if it would be an, you know, the taxes for the year, okay? So keep that in mind as well. Okay, I think that unless you have any questions about that one, I think that's it with that one.
On the CDDs, let's say, because I understand 30-year CDDs, you've been 10 years into the house and you're selling the house and you have 20 more years left. Can we negotiate if the seller includes on the price of the seller? In other words, if the seller pays for the remaining of the 20 years of the CDD from the profit of the sale?
Yeah, that's a way actually to negotiate it. You will have to negotiate it to such as like a reduction in the purchase price. You know, that's really the way, because other than that, that's something that shows every year in the taxes. How am I going to be able to, you know, calculate 30 years or 20 years, you know, after closing to make sure, you know, that I collect for that? I can't. So you will have to take that into consideration as to the price of the home and then get a reduction at the price of the home level, okay? Otherwise, but what the contract says is that we're required to do it as a proration, like regular taxes every year, okay?
Yeah. Excellent. Thank you, Inalvis.
You're
So
welcome.
on disclosures, here, there's a bunch of disclosures that they used to be separate. So each disclosure were integrated into the contract. They used to be separate disclosures. So you have a contract of 5 pages and different disclosures. Now they put it all together. They're all in the ASIS contract. I don't know if you want to cover all of these one by one, or just, I mean,
No,
it's
I don't
self-explanatory.
think, I don't think that we need to cover one by one, because then we will be here, you know, talking
Until
about this like
tomorrow.
forever. But just keep in mind, there's certain disclosures that the seller always gives the buyer in residential transaction. Some of them are included there, okay? And there's certain things that the seller has to go ahead and confirm if they apply or not. For example, if the property is in a flood zone, okay? But other than that, there's nothing really for you to do with those clauses. You cannot delete them, you cannot cross them out. You know, they're there for a reason and they should stay there, okay? Whether it is for as a protection to the buyer or a protection to the seller, okay? And talking about disclosures, remember that there's also the seller disclosure that it should be included in the contract. And I know that that one is missed a lot. And I know that the excuse that sellers give me, oh, I never live in the property. It doesn't matter. If you didn't live in the property, you still fill out the disclosure. But there's a section that says, yes, no, I don't know. Then the answer will be, I don't know, because if you don't live in the property, I don't know. You don't know if there's a leak on the roof unless the tenant tells you, okay? But don't lie, because if the tenant tells you, hey, there's a leak in the roof, you have information, you know, okay? So the seller should disclose it.
So listing agents all should include in the listing package the seller property disclosures. And by the way, you cannot fill out. It has to be filled out by the seller. They have to do
Absolutely.
it by hand, and they have to sign an initial every page, 5 pages, seller property disclosure, because that's a CYA form. That's release you from liability in case something happens, because guess what? They're gonna sue you as an agent because you knew what was going on and you didn't say it. So in order to avoid that, always with the listing agreement, get a seller's property disclosure with all the addendums that you need to have. And myself, I included on the MLS as attachments. So if someone wants to make an offer, they just go to the attachment, they find all the documents that they need to include in the seller property disclosures. So it's gonna save you a lot of time and a lot of hassle.
Yeah, I agree 100%.
So moving on, property inspection. This is very important. Very important.
And
For some reason, for some reason they have it in bold letters, big bold letters. So
yeah, let's say that the reason why it's in bold letter is because it's my favorite deadline. Okay, that's the way that I always tell the agents for them not to forget. That's the favorite deadline of that Ina, you know, has within the transaction. And why do I always say that is my favorite deadline? Because the buyer could walk out for any reason. And people keep telling me, Ina, you're talking about any reason. Is any reason the inspection? No. Any reason. I signed a contract today. I had a dream about the property. I woke up the next day. I dreamt, I don't know. There's very people that they're very superstitious, and I always make an example, you know, for people to remember. I dreamt that they were gonna kill me inside the house. You know, they came into the house and they were killing me in my dream. I do not want the house. I could walk out of the contract if my due diligence or the inspection period is alive. Okay, that's why I always say any reason whatsoever. This is the time that the buyer has more power in the transaction. Okay, having said that, you should also do an inspection. Okay, because I have buyers that told me, oh no, I'm not going to buy the property with an inspection. And I always tell them, no, go get the inspection. Don't save the $300, $400, because then you're going to have a bunch of issues. And sure enough, they end up having a bunch of issues. Okay, so due diligence. Do your physical inspections, or not you, recommend your client to get the physical inspection, okay? Get the report within the time that you have, okay? And the buyer could cancel for any reason. The question that I always get, Ina, I did the inspection, but the inspector is not gonna be able to give me the report until after the deadline expires, then you need to get an extension. Get an extension. How are you going to let the period expire if you don't have the report from the inspector? Okay, get the extension. Very important. Second point that people told me, this is an assist contract. I cannot even negotiate. No, you will still negotiate. If you have something in that inspection that is not acceptable to your buyer, you could go and try to negotiate. Give it a try. It might be that you get something for your buyer. You might get a credit. You might get a repair, okay? My recommendation when repairs are involved, okay? This depends on the buyer, but my recommendation would be get the credit, not the repair, because the credit is money that I could have and I could do the repairs to my satisfaction. When I get a repair from the seller, I do not know if they really do the repair correctly, okay? So what I get sometimes is that they made a repair, they didn't do it properly, and then after the closing, the buyer is calling me, Ina, they didn't do this correctly, okay? So keep that in mind. Some sellers are gonna tell you, no, I am gonna repair, and at least you get something, you got the repair, okay? But if you get a credit, it's better, in my opinion, than the actual repair from the seller. Unless your buyer tells you, I do not want to deal with this, then try to get a repair, okay, before closing. Guess what? Not because the seller tells you verbally or the listing agent tells you via WhatsApp or via text message, you're going to get the repair. Make sure that it's in writing, an addendum. Anything that you negotiate during this phase, they're going to give to you, make it in writing, an addendum to the contract, okay? And if the deadline is expiring, and you don't have what you need, get an extension, because after the deadline expires, the buyer is not going to be able to cancel for any reason, okay? It has to be for a specific instances like financing, very specific title, things like that, but not for any reason. This is why this is my favorite deadline, okay?
Yes, somebody's asking that, or someone's telling, I thought there was no repairs in the assets contract. You just answered that. There is, everything is negotiable on the contract. Everything, basically everything. Dates,
Absolutely.
conditions, extension to dates, everything is negotiable. Who pays what? Everything is negotiable. So basically, when you have this, and this is very important, when you put on the offer that you have 7 days to do the inspection, you have 7 days to cancel. Don't wait 7 days and do the inspection and cancel on day 8 because you're done. You lose basically the provision that prevents your buyer. You put in the deposit basically in the seller's hands if you do that. So if you put on the contract 7 days for inspections, you have 7 days to cancel if you're not going to continue with the sale. Otherwise, your buyer is going to lose the deposit. Correct?
Yeah, absolutely, within the deadline. Before the deadline, you cannot just let the 7 days expire and then all of a sudden cancel or go ahead and try to negotiate a repair. Okay, at that point in time, you might get lucky if you have a seller that is willing to go ahead and negotiate, but they pretty much are going to tell you, don't talk to me about it. Okay, and I tell you, this happens even between attorneys. I had attorneys that I go and making the call, and for some reason, is the deadline, and they told me, why are you talking to me? I'm not going to negotiate. I'm not even going to present it to the seller. Okay, so keep that in mind. Keep in mind the deadlines. Mm-hmm.
Yeah, there's this can kill the deal, and you put in the buyer at risk, the deposit at risk. Okay. Absolutely,
and about the deposit, remember that I always tell you, $1, 100,000. 50, 25,000, whatever amount of money is a huge amount of money because it's not your money. It is not your money, it's your client's money, okay? So we never play with the deposit of the client, even if it is $1, because it's not our money, okay? Keep that in mind all the time. All the risks, all the decisions are to be taken by your client, not by you. You might end up making the wrong decision. You might end up getting in trouble because you made the decision on behalf of your client. Okay, keep that in mind all the time.
All right, the next is going to be the walkthrough inspection, which is a re-inspection of the house, but just visually when you do, I recommend to do the walkthrough the day of closing. And why I say that, because you can do a walkthrough the day before, and then the day of closing, there is an issue. Once you sign, you're done. You have no recourse.
Absolutely. I had a client for you to see how important this is, that did the walkthrough a day before closing, okay, early in the morning. He did the closing the next day early in the morning. When he went to the property, somebody had stolen the AC unit. Just to say somebody has stolen the AC unit. You know, what can I do at the point in time? I mean, a fight that I had to try to go ahead and win. But don't, you know, try to do it the day of the closing. That there's no risk of anything disappearing or, you know, any changes. And remember, what you see is what you get. If you saw at the beginning the KitchenAid stove, now you cannot go and see that it's an LG stove. Okay, very important. That's why the recommendation of the pictures, the videos, you know, at the beginning of the class.
Excellent. Seller assistant cooperation in closeout of building permits. I think it's already embedded in our contract that all the closing, all the buildings, closing of building permits, they have to be closed by the time of closing. But be aware of that. If you're using a contract that is not the Canvas contract, it might not be there. So make sure that you protect your buyer. That is if there's any building permit open, to have it closed by the time of closing. Right, Inalvis?
Yes, you need the additional clause, which, by the way, I'm always talking about the clause with Ernesto, and I'm one of the ones that is always recommending changes based on what I see that's happening in transactions. Okay, you always want that one, because that clause that Leo was mentioning, the one that is after the walkthrough, that clause is not going to cover the seller closing the permit. Okay, it's not imposing the responsibility on the seller. You need to impose the responsibility on the seller with the additional clause that you have in every single contract of Canvas. And if you don't have it, copy the clause from the Canvas contract and include it in the other, whatever contract you're using, okay? That's one. I'm gonna say something about permits. Sometimes permits are complicated to resolve. Okay, and I mean, I hate that this is the way, but it is. It depends on the cities. Sometimes for you to close a permit, you have to go reopen. If it is an expired permit, reopen the permit, go get an inspection, which hopefully, you know, it passes.
It passes.
Yeah. Because it depends on the city. And then once they do that, they're going to go ahead and close the permit. Sometimes they come and they tell you, you know something, all this that is done was done out of code, or it was done incorrectly, or you need to revise A, B, C, or D. And then now you're like on the construction again, trying to close a permit. Okay, you want the responsibility to be on the seller, not on the buyer. Imagine the buyer after the closing having to go find the contractor that, I don't know, you know, did whatever modification to the property. Okay. It's not the same. There was no relationship between the buyer and the contractor. The contractor is not going to feel obligated to help the buyer. It's complicated. So whenever you have a buyer that accepts the permits, make sure they understand the process, okay? Otherwise, go ahead and include the clause. If you go to the additional terms of your contract in Canvas, with the one that you have in that loop, the clause is there. That should be the clause that you should be using.
And not to pick on any city, but the beautiful city of Hialeah is a good example of people that do additions and close garage or do an efficiency without permits. Is known for that. What's the way around that? I mean, if you have a buyer, you're going to a property, listed with an agent, they don't disclose that there was an addition done to the house, or the garage, and there's no permits. How do we go around that as representing the buyer?
Yeah, it is very complicated sometimes, and I'm going to tell you why. Somebody could do an addition to the property, okay? And if the city does not see it, okay, like the typical additions that they're made in the garages, okay, because they didn't change anything structurally for the property outside of the property. So they don't see it, they don't know. It might be that they did it without a permit, but it's not a problem whatsoever because nobody has found out about it, okay? There's no violation. The city doesn't know, in other words, okay? So it could be that the buyer buys a property, accepts it that way, and no problem whatsoever. Having said this, if they found out about it, then something that was done without a permit could becoming a co-violation, okay? And once it becomes a co-violation, then now you are violating, you know, the building department's rules and regulations of the city. So that means that there could be severe consequences. One of the consequences is that most of the times you get a fine, and those fines are usually daily fines that usually run between $150 and $200 per day. So imagine a situation where the addition was done 2 years ago. Now there's a violation, and the fines have been accumulating for a year. Very expensive. Okay, it could be that in order for you to fix that violation, there has to be either inspections, or they have to go ahead and go get the contractor again. They have to do everything up to code. It could even end up being something that you need to demolish. Okay, so very tough situation. In addition to that, because you need to go ahead and fix the violation and pay any fines. Imagine a huge fine. I had a client that had a $93,000 fine just in fines. Okay, and for you to resolve that, you need to fix. He had to demolish a $300,000 addition that he had to the house, and he had to pay the fine. And you don't want the buyer buying a property in such a state, because it could be very prejudicial to the buyer. Okay, so the clause also talks about co-violations, and the reason why it has caused violations is because situations where permits were not pulled correctly usually tend to be violations, co-violations with the building department of the city. Very expensive, hard to go ahead and mitigate, because sometimes you can mitigate, but it's hard to get a reduction. And they cost money, because you usually have to go and hire an attorney for them to go to a hearing with the city to try to mitigate the balances. So keep that in mind. Always include the clause. Okay, when you represent the buyer, always include the clause. If you represent the seller, that's another story. Remember that your client comes first. If I represent a seller, I'm never going to include a clause. Okay, but most likely the agent of the buyer is going to go ahead and include it. Okay, so keep that in mind.
Yeah, the reason I bring that up is because when you do the title search, you're gonna be able to see the open permits.
Yeah.
But in the case that they didn't open the permit, they did it without permits, you're not gonna be able to see it. So when you're taking a listing, for example, it's your responsibility to ask the seller if any additions, any transformations were done using the permits, because that could be an issue in the future. Okay, and you need you know, if you don't know, nobody can tell you anything. But if you do know, you have to disclose it.
Yeah,
correct?
absolutely. And in that case, whenever you find the information, you need to go ahead and tell your buyer, this was done without a permit. It might not be an issue right now. It might be an issue. Maybe the title company calls me and tells me there's no violation, there's nothing appears on the lien search, but maybe the title company calls me and tells me, listen, there's a violation, a co-violation related to that. So you have to inform your client all the time,
Yeah, I don't know anybody that is being sent to jail for over disclose, right?
No, I haven't met that person yet either, but I always say, if share with you, then it might be a problem when you don't disclose,
Right. Excellent. So on the escrow agent, this is self-explanatory. It's going to tell who's going to hold the escrow, which is different than who's going to do the closing. And that's important to know, because the title company or the attorney or anybody holding the escrow, that doesn't have to be the one that's going to do the closing.
Absolutely.
So when you submit an offer and you put the escrow money with Title Logic, let's say with our title company, that doesn't mean that they're going to do the closing. At closing, if this is another title company, then Title Logic is going to send the money to that title company. So escrow is one thing, closing is another thing. So know the difference between one and the other. Let's keep going here. Inalvis, we're almost done, guys.
Everything else that's coming in the contracts for like about 3-4 pages, more or less.
Yes.
They're there for a reason. okay? And they should stay there for that reason that they're there, okay? You cannot modify, you cannot delete. If there's anything that you need to change because of an agreement between the buyer and the seller, because it is a concern, what I recommend is adding an addendum to the contract, okay? Those clauses, if you look at them, they don't even give you the option to select, to you know, modify, to do anything with them. So usually they're standard procedures, or you know, of real estate. And why are they there? Because you might think, oh, they're there, but nobody cares about them. No, because they're there because they guide you as to certain aspects of the transaction. You know, sometimes I have a dispute and I end up going to one of those, you know, and people told me, where do you get that from, Ina? Where do you get that from? Because they're there for a reason, okay? It's just that sometimes we don't read, or we don't want to read, or you know, we don't have to do anything with them, so we don't pay attention to them, but they're there for a reason. Just keep that in mind. Don't be going to the habit of deleting and modifying and all that, because typically you cannot do that because you're not an attorney. So if that's needed, that's something probably for me to do, you know, to give you an idea, and you will have to come to me and I will tell you, you know.
Right. So basically the pages that you're gonna have to fill in the blanks is gonna be pages from 1 to 5, and then you're gonna jump to page 11 of the contract. That's very important because this is where you're gonna mark all the addendums that are gonna accompany the offer. So whatever addendum you need to send with the offer, you have to mark it here as accompanying the offer. So that's on page 11. So 1 to 5, you need to fill out in the blanks. Then page 11, you're gonna have to mark all the addendums that are gonna accompany the offer, whatever the case is. If you have a condo rider, if you have an HOA, if you have a FHA addendum, if you, whatever addendum you're gonna include, if it's a property built before 1978, the lead-based paint, you're gonna have to mark it and you're gonna have to add it to the offer. Right now,
yeah, yes, and remember that if something is marked there and it's not included, you have an issue with the contract, okay? So first of all, things to keep in mind, don't go crazy selecting addendums that you don't need, because that happens also. All of a sudden I get addendums and I go, what's going on here? And sometimes it's because you don't understand the addendum. I mean, call me before you do that. If you have any doubts, call me, send me a text message and I'll respond to you. Okay, select the ones that do apply and are necessary. There's some of them that they're a must, and you cannot forget, like the condo rider, the HOA rider. If you know, if the property is a condo or is within a homeowners association, you need to include those. Okay, and then use the other ones depending on whether you need them for this transaction or not. Get into the habit always of marking them, because if you mark them, I know that the contract comes with them. And when I say I know, it's me, Leo, anybody that's involved in the transaction, you know. If you do not mark them, then we don't know, okay? And we have no assurances that what you're including is supposed to be included or not, or you know, or you miss it. So keep into the habit of marking that. And you know, like, know them. There's a bunch of them. Aside from this, you have other addendums that they're not listed here. Use the one that's called other. There's a section that says other, mark that one and include the name of the addendum, okay? There's plenty of addendums out there. Sometimes you even have 3 addendums that you could use for one term. You know, just play a little with that loop. One day that you don't have a lot going on, sit down and say, oh my God, I could use this one for this one. I could use this one for the other one. And it's going to alleviate sometimes the stress that you have, that you told me, I had no idea where to put this. I had no idea. If you have no idea, there's an addendum that is blank. It only says addendum to contract, and it has a box that is blank. You could add there anything, okay? That one is as valid as any other addendum, okay? So don't think that because you don't have one title for the specific thing that you want, there's nothing out there for you. Okay, use that one. I use it all the time, by the way.
Excellent. So what that brings us to page number 12, the last page of the contract, where we have the additional terms. And here's where we're gonna put, let's say that if you're asking for any seller concession, if you want to write down anything that is not already on the contract, then you can add it here as an additional term. By default, you're gonna have the 495 fee, the buyer or seller fee that's gonna be paid to Canvas at closing is already there, and the terms that the seller is gonna be responsible for closing any open permits is gonna be there if you use the Canvas contract. Okay.
Yeah.
What else would you include here in Inalvis in additional terms in any case?
Anything else that you have discussed, or buyer and seller you have discussed with the listing agent, okay, verbally, that is important to the transaction. Anything else, okay? Remember that everything has to be in writing. Okay, so you disclose, you spoke to the listing agent, okay, for example, and the listing agent told you, the buyer needs to apply to the association, but the association, this is happening nowadays a lot, the association is requiring the seller to go ahead and request the estoppel prior to the application, okay? And you discuss it with the listing agent, and the listing agent tells you, do not worry about it. We're gonna go ahead and do it, okay? Put it in the additional terms. Put it in writing. Any agreement, anything that later on, memory fails. Remember that I always say, when you're negotiating, when you're talking to the other side, sometimes the other side is telling you what you want to hear, okay? Put it in writing. Let them be responsible for what they tell you. Sometimes you're negotiating and you told me, oh, Ina, we spoke about this and that and that and that and that. And all of a sudden I go, but wait a minute, where is that in the contract? Where is that? That's where you need to put it, in the additional terms, in that blank addendum that I spoke to you about, okay? But you need to put it in writing. This is not our countries where we were born, that, and it happens to me a lot with my clients. Oh no, Ina, we did everything with a handshake. Good, amazing. I'm happy that at some point in time we had that assurances that we could do business with a handshake, but that's not in the United States. In the United States, it doesn't work that way. I talk to you about something, and unless I care a lot about what I'm telling you about my work, most people, they come and they tell you, oh, I never told you that, or you misunderstood. You didn't know what I was telling you, or you didn't understand what I was telling you. You don't want that, so put it in writing. The best way to keep the transaction clean also, is to put things in writing, because remember, you're not the only one working on the transaction. You have lenders, you have title companies, you have many other professionals that they might need what you believe that everybody knows and nobody knows. They might need it in writing for them to know, okay? Yeah. So keep that in mind. The clause is blank for a reason. There's no reason why you shouldn't add what it needs to be added, okay? That's very important.
Well, in real estate, it has to be in writing in order to be enforceable. You probably learned that in class number 1 of real estate school. It has to be in writing in order to be enforceable. So put everything in writing. Again, nobody that I know has gone to jail for over disclosing and for putting everything in writing. So there's no misunderstanding. What else now is just to finish?
The only thing that I had to say is that remember that there's a very important section in that page, which is the commission, is the agent section. Make sure that your name is there. If your name is not there, we're going to be wondering, who do I pay the commission to? Is that person either, is the person going to even be paid a commission? Okay, so make sure that your name, your company is there.
Do you suggest also include the commission that it shows on the MLS? Because in some cases, I've seen some cases, I'm not going to mention name or anything, but some cases they said on the MLS, you're going to get paid, let's say 3%. But when you get to closing, you find out that it's 2.5% or 2%. So it's recommendable to put on the contract the percentage that is showed that you're going to get paid on the contract that was says on the MLS.
Yeah, there's a lot of people that told me, no, Ina, I don't want to include it, or I'd rather not include it, or, there's a lot of views about this. My personal opinion about it is included. Why? Because it is there and you could use it as reinforcement. MLS says 3% you included in the contract. Okay, anyways, for you to know, MLS regulates, okay? But you include it in the contract, don't use it to deceive anybody. You include it in the contract, and the seller, who's the one signing, is gonna reinforce, that's the commission, yes, that's right. Otherwise, they should come back and tell you, no, it's 2.5%. You didn't read correctly, okay? So I always recommend it, and I myself add it whenever I represent a client and I'm the one doing the contract as an attorney. Why? Because it serves as reinforcement that that's the commission that the seller is going to pay. In the event of a dispute, I had to go to the leasing agreement, the MLS, you know, because those are what regulate, but I always confirm. I had 3% and 3%. Now they're telling me 2.5% and 2.5%. So it gives also the ability to the title company to confirm. If they owe you 3%, it's going to be 3%. Okay. So I would add it. I don't see why not. I recommend it that you do. And remember, include your name, include your company. Okay. Those are basics. But unfortunately, I have seen contracts that they're blank, you know, for some reason.
Who are going to pay now?
Yeah, exactly. So other than that, I think I don't have anything else to say about that page. The contract, I do want to say something that is very important, that sometimes you agents do not see it as me as an attorney, but I want to give you my point of view from my angle. Is the contract is all in the transaction. Okay, the contract is pretty much what's going to regulate that transaction. So take it seriously. Okay, take it seriously, because my transaction is going to go depending on the contract. I think it's one of the most important things in real estate transactions. You know, this is why I cannot stress enough to take it seriously, to fill it out correctly, to take your time. This is not a game. You know, this is not a competition. I know that the market sometimes it makes you want to do things fast, but when you do things fast and you don't review, you don't take your time, you make mistakes, and then there's disputes, there's issues in the transaction. Okay, a transaction could go as smoothly as possible or as horrible as possible because of the contract. Okay, so I think, yeah, I think that that's something that we all, including me, we need to pay attention to. And we need to give it the value that it has. Okay, so I hope this seminar, you know, help you. I think it was a great idea to do it this way, because it, you know, with the question and answers, it keeps you awake, it keeps you involved. You know, I'm gonna leave it to Leo. If there's any questions, you could always ask the questions here. You could always text me or call me after. Most of you have my cell phone number. Okay, but just make it important. This is the most important thing in the transaction, the contract.
Absolutely, absolutely. I agree with you 100%. Well, if there is no more questions, I don't see any questions for the attendees. Thank you, Inalvis, again, for taking the time. It's been 2 hours with you, taking your time and your knowledge. Thank you again, and thank you the attendance to the meeting, and have an excellent day. Have a wonderful day, guys. Let's be productive.
Same to you guys. My pleasure always to be here. I look forward to seeing all of you next month in the offices, and I look forward to seeing you too, Leo, next time that we could see each other.
Wonderful. Remember, we have the training for Monday, Tuesday, and Wednesday. Okay. Next week. We're gonna have in Western the new agents orientation. There's a new question here, the last one, or it's a thank you. So thank you, guys. Thank you, Inalvis, again. Have a wonderful day, guys.
You're welcome. See you Monday in Weston.
Thanks.
Bye.